Okay, guys, I wanted to run something by you because I think this is going to be quite a big case that we all could have an input on given our backgrounds. But I'm going to be acting for wife in a divorce. Large family business whereby her husband's got a majority share, but the kids work there as well as the grandfather. Obviously, she doesn't work there in any capacity. She has got shares by virtue of being wife only. She is going to want, obviously, sufficient money to rehouse. She's very aware that she is going to be losing an income from leaving the marriage. So it's, from my perspective, I'm thinking next steps are going to be what? I presume a business valuation is going to be needed. I know you've got a lot of experience in this area, Dave.
In a case where there's a large limited company with a multiplicity of shareholders, I'd expect there to be a shareholders agreement in place, and that shareholders agreement would set out precisely what the procedure is for an outgoing shareholder who is to purchase their shares, how their shares are to be purchased, how the value of those shares is calculated. The family court is not going to overrule that procedure. Firstly, the court will say, follow that procedure and then see where we go to. The court can then revisit the marital assets after that. So shareholders agreement is where we would start, I think.
What if there wasn't a shareholders agreement, then what would happen?
If there isn't a shareholders agreement, then I think a competent business-like accountant could prepare a valuation of the business and can calculate what amount of remuneration, what amount of consideration should be paid to the outgoing spouse. I think that would be an appropriate thing to achieve, and that wouldn't cost a lot of money to get a valuation like that.
So what if the business was a cash business, like a bar or something like that?
If it's a cash business, then it may be that the business is merely just an income stream, and so that could then be treated in the same way that you would treat a PAYE employment. So it's how the profits are divided between all of the parties, including the shareholders. That might be a bit more difficult to deal with, but again, I would expect a competent accountant to be able to prepare that valuation report.
I think the problem is we know wife is going to know the ins and outs of how this business is run, how money is divided between the family. Not all money is going to be declared if it is cash, like you say. So I'm wondering how good a valuation is actually going to be. Is it going to tell us the full story?
I would expect a competent accountant to give a broader view of the business other than just the cash income that's received. There's going to be an amount of goodwill that goes with that business. There's going to be some assets, I would expect, even if it's minimal assets. And the accountant would also look at what the market is out there, what somebody might be prepared to pay for that business or to take a share of that business. Obviously, if it's a family business where all the shares are held by family members, that's going to be less attractive to a potential purchaser than if it's a limited company with a range of different unconnected people.
Didn't you have this on a case study when you dealt with was it pizza van?
Yes, Dave had one, didn't he, where they both owned pizza vans, and ultimately they decided that they would take a van each as part of the settlement. Always important to get the financial order, isn't it, in place? But that was one of Dave's. That was quite an interesting one, wasn't it?
It was indeed. I don't want to be monopolising all of this, just me speaking. Come on, guys.
I was just going to say that shows how flexible the courts can be as well if you can have an order like that. Obviously, it's quite useful because obviously financial situation can be really complicated. So it's good to have that kind of flexibility if you need it.
The family courts tend to operate in the real world. A lot of people think that the judges are going to be stuffy and out of touch, whereas the judges that we have, particularly in this area, are very pragmatic, very knowledgeable. They live in the real world, and you actually get real life answers rather than some strange settlement that nobody agrees with.
So I think what we're going to have to be thinking here is actually, does she still want to keep her shares in the business? Because if the value is higher than she thought and it's giving her a good income that she needs, maybe she needs to stay in that company.
If she has no practical input to the business now, then why should that change just because they're divorced? Presumably her income is going to be decided by the dividends that are paid out to her on the shares that she holds. Well, those dividend calculations are going to continue in the future exactly as they have been in the past. It's just an income stream for her.
But then in terms of clean break, you're not really having a clean break then because you're still connected to your ex-husband, especially if it's been a particularly traumatic marriage or there's been domestic violence. You know, I wouldn't want to stay in that kind of situation. I'd want a clean break and I'd want to move on.
Yeah, she's going to feel like an outsider, isn't she, as well, because she's now not going to be part of that family in the strictest of sense.
Shareholder meetings and things like that. She's obviously not going to be involved, or it's going to be awkward for her as well. You have to think of it like practically as well in real life.
So I think we can give her that practical advice as well, and not just the legal advice. Ultimately, do you think this is something that we need to decide in court, or could we deal with this outside of court?
I think if you had two collaborative lawyers, and you being a fully trained collaborative lawyer, if you had two collaborative lawyers, I think you've got a much better opportunity to keep the matter out of court and find a settlement outside of court, rather than old-fashioned lawyers who simply want to roll their sleeves up and battle it out and would prefer then instead to have the matter settled at a hearing.
Yeah, because it's quite sensitive, especially with the children as well. They're not going to know where to turn. They're living with mum. They're working in the family business. I think you're right. I think dealing with this collaboratively is going to be the best way forward, and we can have those financial experts or an accountant who's part of the collaborative process join in the meeting if they're a member of resolution, and that could be a way of then resolving all the financial issues as well, and understanding what everything's worth.
My view there is that the longer you can keep the parties talking to each other, then the better it is, and the more likely it is that you'll reach an agreed settlement. It's when the parties become polarised, and often they employ lawyers to be their prize fighters for them, and they become very much separated from each other. They take up then difficult positions, and then it can only be resolved through court with an independent third party called a judge making the decision for them. So collaborative law is the way forward, I think, from now on.
And obviously, if she wants to fight it for whatever reason, when we know to wear a different hat that day.
So also understanding collaborative, you can complete your D81 statement of information and sign your consent order within that meeting, which is really useful because you've got that pressure there to get everything sorted in that meeting, and obviously it can be more cost effective to do it like that, especially if there's a lot of back and forth between parties.
Exactly. I mean, this is going to be potentially a costly case. Collaborative cases can sometimes halve the fees. So if it is the fact that the wife wants to keep the money in the business as well for ultimately the children, then yes, let's deal with it in a cost-effective manner. You're just eating into their money at the end of the day, aren't you? By going to court.
I think by adopting a collaborative approach, you probably are likely to be able to agree the identity of a single expert to provide valuations or to provide expert advice, whereas it's all too common in court-based proceedings where the parties demand that they get their own valuations. They become competing valuations with a judge having to decide which one is the most accurate, and that just makes it more expensive.
Yes, and then that could be an issue though, because if we're dealing with cash and then wife knows that there's going to be hidden cash potentially, then how effective is that valuation going to be? We could end up having two valuations. So I'm still not sure whether or not this is going to be dealt with collaboratively. I would hope so.
Well, if it isn't, then the court system is there to resolve these type of issues. The court will always be the final arbiter. And if the parties simply cannot reach an agreement, then that's why we have judges who make those decisions for the parties instead of them making those decisions for themselves. The practical difficulty of that is that as a party you lose control of the matter because you're relying on what the judge is going to decide, not what you want to decide with your other partner or spouse.
No, thank you for that.